Imagine waking up, getting your morning tea, and suddenly finding out a criminal case has been registered against you for a crime you absolutely didn't commit. You're sitting there terrified of an imminent, unjustified arrest. Well, today we are going to dive into an explainer on bail before arrest under Section 498 of the Criminal Procedure Code to look at exactly what happens in that nightmare situation and how the law can protect you. Welcome to the Law Simplified series by Legal Insight Publishers. I'm your explainer, Host A.
And I'm Host B. Honestly, that scenario is terrifying. If the police could be at your door at any minute, what do you even do?
Right. So the very first question a frightened client asks their advocate when they rush into the office is, can we get bail? Because the answer to that specific question dictates everything. It dictates whether they spend the months before a trial at home with their family or locked in a prison cell.
Yeah, the stakes literally could not be higher. So today, we're going to break down exactly how you can legally protect yourself before those handcuffs ever come out.
Exactly. To understand how Pakistani law balances the state's power against your individual liberty, we'll quickly cover the fear of arrest, what pre-arrest bail actually is, the three-stage legal test courts use, how the procedure works, bail conditions and cancellation, and finally, some practical tips.
Okay, we've got a lot of ground to cover, from that initial panic all the way to securing your freedom. Let's get into it.
Part 1. The fear of arrest. Let's start with that immediate anxiety of facing a potentially politically motivated or totally malicious FIR.
You know, I hear this phrase all the time in legal circles. Bail is the rule, jail is the exception. But is that really true in practice here in Pakistan?
It absolutely is. It's the fundamental principle affirmed by the Supreme Court of Pakistan in an unbroken line of decisions. An unconvicted person is always presumed innocent. That means the onus, the burden, is on the prosecution to justify putting someone in pretrial detention, not the other way around. It's rooted right in Article 9 of our Constitution, which protects personal liberty.
Moving to Part 2, what is pre-arrest bail? This is where the law proactively steps in to protect citizens.
Okay, so break this down for me. In Urdu, people usually call this ضمانت قبل از گرفتاری, right? Hit the nail on the head. Legally speaking, it's known as anticipatory bail under Section 498 of the CrPC. Pre-arrest bail is designed specifically as a safeguard. It stops the criminal justice process from being weaponized as a tool of harassment. And it's totally different from post-arrest bail, which is what happens after you're already in police custody.
Does this protection apply to every single crime out there?
That's a crucial distinction to make. You actually only need pre-arrest bail for non-bailable offenses. See, for bailable offenses, which fall under Section 496, the police or the court must release you as an absolute right. But for non-bailable offenses under Section 498, bail is entirely discretionary. The court has to find reasonable grounds and sufficient cause to grant it.
So if I need this protection, where do I actually go? Do I just run to the local magistrate?
No, definitely don't do that. You can't go to the magistrate for this. While the High Court and Sessions Court have concurrent jurisdiction under Section 498, in practice, you almost always file your pre-arrest bail application in the Sessions Court first. Bypassing them and going straight to the High Court without an incredibly good reason is heavily frowned upon.
All right, on to Part 3, the three-stage legal test. Let's look at the actual legal hurdles you have to clear to win this protection in court.
I'd imagine judges don't just hand this out to anyone who asks, right? Like, there has to be a strict criteria.
Absolutely not. It's not a free pass. Look at this landmark Supreme Court ruling from 2011. It clarifies that pre-arrest bail is an extraordinary power. It is strictly meant to stop police powers from being abused for personal grudges or political pressure. The court has to clearly see that there is malice involved, carefully balancing your personal liberty against the broader public interest.
So how does a judge actually decide if there is malice? What's the test?
Well, Pakistani courts systematically apply a three-stage test. First, they ask, does the FIR show a clear prima facie case against you? Second, is there mollified, meaning was the registration of the case motivated by bad faith or a high likelihood of false implication? And third, the balance of convenience. This weighs the irreversible harm of unnecessarily arresting an innocent person against the state's need to investigate.
To give you a real-world idea of mollified or bad faith, think of this example from our source material. Imagine a business partner files criminal charges for breach of trust the exact day after they lose a civil lawsuit over the exact same commercial dispute.
Oh, wow. So they lose in civil court, get mad, and immediately try to use the police to harass their partner instead?
Precisely. That highly suspicious timing is a massive red flag.
It's exactly the kind of concrete evidence a judge looks for at stage 2 of the test to prove malice.
Section 4, how the procedure works. Let's get into the actual timeline from the moment you decide to fight the FIR.
Let's make this super practical. Say I find out about an FIR against me today. Walk me through the next few weeks. Okay, on day 1, your defense counsel files the application with a supporting affidavit. The court will usually grant a temporary protection called interim bail or ad interim bail for about 10 to 15 days.
Meaning I am protected from arrest immediately?
Yes, this protects you right away while the main application is scheduled for a hearing and the state is formally notified. But during that interim time, you absolutely have to join the police investigation. Then, a few weeks later, you have the final hearing where the judge decides to either confirm your bail or cancel it entirely.
Which brings us to Part 5, bail conditions and cancellation. Getting that interim bail is only half the battle.
What kind of rules do they put on you during this time? Courts impose pretty strict conditions. You might have to surrender your passport, provide a financial surety, and avoid contacting any prosecution witnesses. But listen, the single most critical condition is joining the police investigation. Failing to cooperate with the police when directed by the court is a primary basis for having your bail immediately canceled. Okay, but what if I genuinely miss one meeting with the investigating officer? Say I was sick or there was a genuine miscommunication. The law actually has some nuance there, thankfully. The Lahore High Court clarified this. If you miss just one appearance, the court must check if the investigating officer was genuinely seeking your cooperation or if they are just using your absence as an excuse to get your bail canceled so they can lock you up. However, a pattern of deliberate non-cooperation, that will definitely result in cancellation at your final hearing. Also, for heinous crimes or terrorism offenses, courts are naturally way more strict and will often refuse or cancel bail entirely.
Finally, Part 6, practical tips. Let's wrap up with some highly actionable steps derived right from Chapter 15 of our source text.
So bottom line, what is the very first thing a person should do when they learn they've been implicated in a case? Do not ignore it. Seriously, your absence only makes the situation much worse. Engage a competent lawyer immediately. A successful bail application has to be specific. You need to highlight the exact weaknesses in the prosecution's case and clearly demonstrate your roots in the community to prove you aren't a flight risk. Keep your CNIC ready. Make sure you classify the offense correctly and get your documents in order before you ever step foot in a courtroom.
You mentioned providing a financial surety earlier. Who can actually step up and do that for me?
A surety has to be someone who is financially capable of meeting the bail obligation. It's a big responsibility. They cannot be a minor, they can't be a co-accused in your case, and they can't be someone who is currently out on bail themselves. You have to verify your sureties carefully, because the court will execute a bail bond under Section 499. If you abscond or run away, your surety will forfeit whatever money or property they deposited.
As we reflect on the delicate balance between state power and individual freedom under Article 9, I leave you with a question to consider. Do you think Section 498 as it stands today is robust enough to protect innocent citizens from malicious prosecution?
It is definitely a complex balance and really makes you think about how these laws play out in reality. Thanks for breaking down Section 498 CrPC so clearly for us today. For everyone watching this explainer, if you found this helpful, make sure to like, subscribe, and drop your legal questions in the comments below.
Absolutely, we'd love to hear from you. And for more in-depth knowledge, be sure to check out the Legal Insight Publishers website and the Law Simplified series books. Thank you so much for joining us for this explainer. Allah Hafiz and take care of your rights.